Okay, I'm just going to turn the recording on, just so we have it.
Okay.
Okay. All righty. Did we, Rob, I can't remember, it's been a really hectic few days. Do we discuss, I know I'm going first because I'm arguing against it. How much time do I get? I just want to make sure we have the right time. I don't remember what we agreed to.
Just roughly 10 minutes.
10 minutes? I can live with 10 minutes.
Yeah. And then he'll have 10 minutes. Mr. Weiner will have 10 minutes, and then we'll just do like maybe 5-minute rebuttal times.
Okay, 10 minutes, I can do that.
All right. Well, I will go ahead and get us started. It's 1 o'clock. All right. Good afternoon, everyone. My name is David Hawkins, and I am the New York Law School Federalist Society president. On behalf of New York Law School Federalist Society and our co-hosts, the South Texas College of Law Federalist Society, the New York Law School Student Bar Association, Jewish Law Students Association, and Christian Legal Society, I would like to welcome you to today's debate entitled Rule 8.4G, A Wolf in Sheep's Clothing. The Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the legal community through its programs and publications about how limited constitutional government based on the rule of law can have a positive effect on law and public policy. Our moderator for this debate is New York Law School's Professor Rebecca Roiphe. Professor Roiphe teaches professional responsibility at New York Law School and is frequently quoted as an expert on legal ethics and criminal justice in the media. She is quoted in the New York Times, the Washington Post, Bloomberg News, Vice News, and the New York Law Journal. Opposing this rule is Professor Josh Blackman of the South Texas College of Law. Professor Blackman specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. He is a graduate of the George Mason University School of Law and is a former clerk for the Judge Danny J. Boggs of the U.S. Circuit Court of Appeals for the Sixth Circuit and Judge Kim Gibson of the U.S. District Court for the Western District of Pennsylvania. Supporting this rule is attorney Robert Weiner. Mr. Weiner is a partner at the internationally known law firm of Porter & Arnold. He is a graduate of Yale Law School. Mr. Weiner is a former Associate Deputy Attorney General of the U.S. Department of Justice and former Senior Counsel in the White House Counsel's Office. Mr. Weiner began his legal career as a law clerk for Judge Henry Friendly of the U.S. Court of Appeals for the Second Circuit and as a law clerk for Associate Justice Thurgood Marshall of the United States Supreme Court. On behalf of all those attending, thank you to our esteemed guests for taking part in today's debate. I will now turn the floor over to Professor Roiphe, who will offer a few introductory remarks.
Great. Thank you so much, David, and thank you for organizing this. I'm thrilled to listen to our speakers on this very interesting subject that's actually very timely in New York, because New York is considering its own version, struggling to find a version that would run into fewer problems that Professor Blackman is going to mention later on. But I did want to start, just because some of you may not be totally familiar with this rule, with a brief description of the rule, and then I'll turn it over to our speakers, because I really want to hear from them, but I just want to make sure everybody understands what the rule essentially says. And we basically refer to it as the anti-discrimination rule, but it's a rule that bars discrimination and harassment based on any number of groups. The rule itself singles out multiple groups, many more groups than I think most states do in their state discrimination law. So it protects on economics, it protects groups from discrimination based on economic status, gender identity, and all of the other ones. But there are a number, disability, age, and so forth. The rule also defines discrimination and harassment quite broadly as any verbal conduct or physical conduct that manifests bias or prejudice toward others. And harassment, similarly, defined quite broadly, and also includes sexual harassment and derogatory or demeaning verbal physical conduct. Sexual harassment includes unwelcome sexual advances, the rule, I think, also is been somewhat controversial because it extends beyond the practice of law to law to conduct related to the practice of law. So it is also covers activities in CLEs and other dinners or social events related to law practice. So I want to turn it over to our speakers. I will say that the ABA, and I will admit to being on the committee that recently wrote an opinion, in some ways narrowing the scope of the rule and offering some examples that it said would not be discrimination, that concerns that were out there. And so I'm curious to hear whether our speakers think that this contribution has changed the calculus significantly. And with that, I'll turn it over to Professor Black.
Thank you so much. I am broadcasting from sunny Houston, Texas, where it's a balmy 11 degrees outside. I have power at the moment. Many of my neighbors do not. At any point, this broadcast may shut off, in which case I would encourage Professor Weiner to jump in, and I will do my best to dial on my phone. But so far, so good with power, and it's warm. No running water, but at least I have lights, and have Wi-Fi. Will travel, as they say. The topic today is ABA Model Rule 8.4G. Let me just read it to you, or at least a key point. This rule makes it misconduct for an attorney to, quote, engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, I'm out of fingers, or socioeconomic status. Comment 4 explains that, quote, conduct related to the practice of law includes representing clients, interacting with witnesses, coworkers, court personnel, lawyers, and others, while engaged in the practice of law. Operating a law firm or managing a law practice, and here comes the important point, participating in bar association, business, or social activities in connection with the practice of law. The model rule is just that, a model that does not apply in any jurisdiction. Over the past 3 years, the state courts have been considering whether to adopt it. And full disclosure, I filed a number of comments in states opposing variants of this rule. And also Professor Weiner and I have actually debated before on this exact topic in a couple places. So this is a bit of an old hat, but we hope to bring some new light to this topic. So here's the informal tally. 6 states have rejected the rule. In 3 states, petitions are withdrawn after a comment period. There are a couple states where the comment period closed a couple years ago and still no decision. The Texas AG has said that 8.4G is unconstitutional. By my count, Vermont, and only Vermont, has been the only state to adopt it in its entirety. A couple states have adopted what I call more narrow versions of the rule: New Hampshire, Maine, and Pennsylvania. Recently, a federal district court judge in Philadelphia said the Pennsylvania rule is unconstitutional. In that case, is an appeal to the Third Circuit. And your very own home state of New York is currently considering the constitutionality of this. Considering a variant of this rule. And I've submitted comments, so I have a dog in this fight. There are 4 primary points that I want to make my very limited time. The first is that 8.4G extends the disciplinary committee's jurisdiction to, quote, conduct related to the practice of law. And it can apply to speech that can be deemed harassment. I think this rule would cover lectures given at a CLE event, or even dinner time conversation at a bar association function. That speech would now be subject to discipline if the speaker reasonably should know that someone would find it derogatory. I think this threat of sanction will chill speech on matters of public concern. The rule itself does not express an awareness of how this rule is an intrusion to private spheres of attorney's life. I recognize that over the past couple of years, the ABA and others said, no, that wasn't our intent. You know, they issued a formal opinion, which I appreciate Mr. Ropi was part of. And they said that we don't intend to apply the rule in this manner. And I appreciate the clarification. I kind of wish it would have been in the rule itself and not in these sort of formal opinions interpreting it. So we have sort of this disconnect, but I do appreciate that there's been a concern at this specific point. Second, I think we should recognize that 8.4G goes beyond a lot of the anti-bias regimes adopted in various states. Now, I listed like 10 or 11 different grounds of discrimination. Some states, for example, hadn't barred discrimination on the basis of sexual orientation or gender identity. I don't have any objection to extending the pre-existing rules to those sort of what we call the SOGI, right? The SOGI classifications. But 8.4G doesn't merely expand the grounds for discrimination. It extends it to a category of conduct called conduct related to the practice of law, right? Conduct related to the practice of law. I think we need to take stock and be careful before we start extending the disciplinary proceeding to areas that are more attenuated from what I would call legal practice, right? Issues affecting a representation of clients, a lawyers of fitness, or the administration of justice. As the bar steps further away from that core of traditional disciplinary areas, I think the bar loses their authority in some regard and has to be a little more constrained. In other words, the validity of this provision, I think, turns on what type of conduct is being regulated. My third point is that 8.4G has, I think, chilling effects. The court in recent years has been very skeptical of restrictions on speech. In fact, for some people, it's perhaps too free speech protective. I'm sure a lot of people would agree with that position. There was a case from about 4 years ago called NIFLA versus Becerra, National Federal Life. I can't remember what it stands for. These are the crisis pregnancy centers. These pro-life groups. And California passed law requiring these groups to basically advertise state funding for abortions, and they went to the court, and the court declared the law unconstitutional. And that opinion said, in no uncertain terms, that the speech of lawyers is not some sort of category of professional speech. It is speech protected by the U.S. Constitution. So when I look at a case like NIFLA versus Becerra, I think that these decisions from the bar are in some tension, right? As the bar moves away from the core of their disciplinary function, it becomes more difficult to justify these incursions into attorney speech. My fourth point is that the states have largely rejected this rule. And I think that some states have rejected it because there just isn't the political will for it, which is, it's within their well-being. But a number of states have identified constitutional problems. I want to talk for a minute about the Pennsylvania case. A lawyer in Philadelphia challenged the Pennsylvania rule. He's an attorney for FIRE, a group that's near and dear to my heart. It's a foundation for individual rights and education. And FIRE litigates on behalf of members of faculty and students who are being punished by universities for engaging in speech. One of the attorneys there speaks on some very controversial topics. He talks about Title IX, talks about sexual harassment, right? He talks about domestic abuse. And he filed a lawsuit saying that this law chills his speech, right? Again, Pennsylvania was a variant. It wasn't 8.4G in its entirety, but it was close enough. And a federal judge agreed. He actually found they were standing, which I was somewhat skeptical, but he found they were standing. And he found that the rule violates the First Amendment. I want to just read a passage from his opinion. The judge wrote, "There's no doubt that the government is acting with beneficent intentions. However, in doing so, the government has created a rule that promotes a government-favored viewpoint monologue and creates a pathway for its handpicked arbiters to determine, without any concrete standards, who and what offends." In other words, giving the state the power to decide what is harassing speech, what is derogatory speech, without any sort of established law to base it on, you do threaten to exclude certain viewpoints from the marketplace of ideas. The judge continued, This rule leaves the door wide open for the government to determine what is bias and prejudice based on whether the viewpoint expressed is socially and politically acceptable. But the government cannot set its standards by legislating diplomatic speech because this tide can sweep us all along and admonish minority viewpoints, right? The judge writes, our limited constitutional government was designed to protect the individual's right to speak freely, including those individuals expressing words or ideas we abhor. All right, so let me wrap up. I've got a minute left. I don't have any objection in principle to rules that prohibit discrimination in the profession. I don't. I mean that sincerely. I recognize sexual harassment is a legitimate issue. It's an issue that we have to address carefully and candidly. We can't just ignore these issues. This rule sweeps too far. If the rule had been focusing more on legal practice, if the rule had been limited to sexual harassment and not just this sort of demeaning or derogatory speech, if the rule made clear, as is a formal opinion, that we're not going after a CLE event, I think my criticism would have been muted. But the drafters of this rule wanted to sweep broadly. They wanted to be encompassing. They didn't want people to slip through the cracks. And I think in doing so, they've created this dilemma whereby legitimate speech is being punished. All right, I think I'm gonna have time. I get my 10 minutes are up. Professor Weiner, happy to hear your comments. Thank you.
Thank you, Professor. So J. Edgar Hoover used to insist that all the memos that came to him would be one page, and he would scrawl his comments in the margins. And one eager FBI agent, trying to cram as much into the one page, expanded the margins and left no room for J. Edgar Hoover to write. And he scrawled across the page, "Watch the borders." And for the next 3 weeks, the FBI had extra surveillance on all the ports of entry. Now, I think, like the FBI's border alert, the alarms about Rule 8.4G are overstated. Doesn't mean there's nothing there. It means they're overstated. The rule is not unprecedented. It's not really all that new. And it's pretty unlikely to spawn the hypothetical parade of horribles that people have posited. And we talked, Professor talked about the Pennsylvania case. If the judge there had applied the doctrine of constitutional avoidance and interpreted the rule to avoid the constitutional issues rather than running headlong into them, I think we would have had some clarity that would resolve everyone's problems and that would leave us with an operative rule on discrimination. Let me identify some principles that I think we can agree on. First, although some of the advocates of Rule 8.4 say otherwise, lawyers do not trade their First Amendment rights for a bar license. Second, impositions on lawyer speech should receive no more or less scrutiny than impositions on anyone else's. But within those constitutional boundaries, lawyers should be held to a higher standard of conduct relating to the practice of law. And third, the First Amendment does not permit discipline for a CLE speech opposing same-sex marriage or Holocaust denial or support for the very fine people on both sides of the marches in Charlottesville. I think there's an important distinction that we need to keep in mind when we're talking about those CLE courses, the distinction between discriminating and advocating discrimination. And there is a significant difference. Now, I said the rule doesn't do very much new. 24 states in the District of Columbia had some anti-discrimination rules. 13 more dealt with it in their comments. For several years, as part of the standards for the prosecution function and the defense function. It's been in the Code of Judicial Conduct since 2007. More than anything else, I think it was the symbolic value of this rule, getting it into the black letter, that was important. It's really not that new with regard to scope either. It's not new that it applies beyond the representation of the client. That's true of the discrimination rules in at least 10 states. It's not that true that it regulates the business of law practice. Multiple rules cover that, including what you can name your firm. It's not unusual that it covers speech. We're lawyers, we talk for a living. You can't reveal confidences of your client. You can't say certain things to people who are unrepresented. And the rules currently cover a lawyer's professional life, or even beyond that, outside the courtroom or client relationships. They prohibit conduct involving dishonesty, fraud, deceit, or misrepresentation at any time and in any context. The model rule is arguably more inclusive than any single rule in a state, but I think it has nothing in there that isn't in some rule in a state. It's in fact clearer than the rules and less expansive than rules in other states. For example, instead of the language of the ABA's proposed rule, Alabama has a catch-all that it covers any other conduct that adversely reflects on a lawyer's fitness to practice law. What if a lawyer is a member of a white-only lawyers club? Some would argue that simplicity and discrimination reflects on moral fitness to practice law. Indiana and Missouri's rules have some of the same language as the ABA's, but they lack the Siena requirement. I could go on this. There's rules that, in Michigan, by the way, requires lawyers to treat all persons involved in the legal process with courtesy and respect. I think that's pretty broad. This rule does not target speech. It has, and it does not, I believe, have a chilling effect. It targets discrimination and harassment, which is disparate treatment or abusive and predatory behavior. Now, sexual harassment may involve speech, but it's not, a ban on it is not primarily a regulation of speech. The speech we're worried about at a CLE or other forums or statements at social events are a fraction of what Rule 8.4G covers. So it doesn't target that, certainly doesn't target political speech. Now, let's talk about the chill. The court in the Haggerty case that Professor Blackman referred to said the plaintiffs had shown a reasonable prospect of enforcement, and therefore they were chilled. And he cited instances, he said, of disciplinary and Title IX complaints. Well, I went and looked at those disciplinary and Title IX complaints, and what's significant about them is none of them involved a complaint against a practicing attorney. It was against academics. One was against a judge. The rest of it is criticism in the press of one judge or another prominent person. And that's why the scantiness of what's cited there reinforces my conclusion that this has never happened. That we're talking about a speculative chill. And when we're talking about chill, there's no empirical evidence of it. Courts make chill determinations all the time without evidence that somebody is chilled, but we're in a different context. We're making policy, and it should be data-driven. And here, rules similar to Rule 8.4G have been in effect for years and years, and not all applied outside. Many of them applied outside the courtroom and outside the relationship between the lawyer and client. There's been no study showing a chill on legitimate speech, and such a study is feasible. Now, this isn't a trust us argument. This is a question of how you interpret the rule. And when you look at the rule, the other parts of 8.4 deal with issues relating to the integrity of the profession, criminal acts, dishonesty, fraud, deceit, prejudicial to the administration of justice. We should interpret this provision in line with those other provisions, not look at it and say, this is an outlier compared to those. I will finish with this point. We get privileges as lawyers. We get a monopoly. We got subpoena power. It is fair for the bar to demand a higher standard of conduct in return for those privileges, including a prohibition on discrimination and harassment. But giving up First Amendment rights is not part of the bargain. Rule 8.4G cannot, and because it cannot, it does not outlaw free speech by lawyers. Now, could it be improved? Sure. Should the states graft on their own variations? Absolutely. Brandeis said the states are laboratories of democracy, and he's right. But to call the rule an assault on the First Amendment, in my view, is a grievance in search of a justification. Josh, I think you're muted.
Oh, I'm sorry, but I think after a year I figured this thing out. I think if I can respond just very briefly, we have a lot of points of agreement. In many regards, this is a rule that will address a problem that should have been addressed very long ago. I don't take lightly issues of harassment, sexual harassment, lawyers hitting on female associates, propositioning them for sex. This happens. And if you look at the record of this rule, there was testimony of female associates who said they were being propositioned for sex, that a senior partner would ask them to come back to the hotel room, right? That a partner got drunk over dinner and was making comments to a female employee. Look, I'm with you. I think there's a rule that can probably address these sorts of issues. If there was some way to tweak the rule to exclude the sorts of thing I'm concerned about, then I would. In fact, I've advised nearly 24 states to do that, to actually try to modify the rule. Pennsylvania went through this very strange process where they had 3 rounds of reviews. The first rule wasn't that bad. The second rule actually got a little bit better. They actually incorporated some of my comments. They made the rule a little more narrow. And the third version, they just blew it up, included everything, which tells me that they said, screw it, we don't, we're going to throw everything in. And I think that's why the judge probably ruled the way he did. The court described 8.4G as a sort of Damocles, if you know the mythology, right? Where it's just sort of that dangles over people. And eventually the judge says you have to simply trust the bar that they don't use it in a abusive fashion. In the First Amendment context, the trust us line doesn't work for me. So if we want to maybe go back to the drawing board, revise it, I'm okay with that. New York, I know, is going through a process. I advised them on. I think New York's actually heading in a good direction. I'm so far pleasantly surprised where New York's heading. They're listening to feedback. That's good. But if you do what Pennsylvania does and just throw all caution to the wind, I think you're looking at a PI, a preliminary injunction. And I think that doesn't help anyone. If you actually want to help people, adopt a rule that withstands judicial scrutiny.
So with regard to Pennsylvania, I think it's an object lesson in how a state should not modify Rule 8.4G, not least of which is they put in manifest by words or conduct, which the court seized upon. That put the First Amendment issue, just put it front and center there. Again, I think this is not a question of trusting this. I think that the rule can readily be interpreted in a way that does not cover the kinds of things that trouble us, in particular political speech, speech at CLEs. It doesn't bother me that it covers social events. If somebody wants to hit on an associate at a social event, I think they should be held responsible for that. The rule refers to the federal law and the state law relating to discrimination and harassment, and says that guidance should be gleaned from those sources. And I think that is also a limitation. In that regard, I disagree a little bit with one part of the ABA opinion, which says that harassment doesn't need to be serious or pervasive in order to violate the rule. And I disagree because I think in the employment context, it should be, in order to match the federal and state discrimination laws, in that context, it should be severe or pervasive. But when you're talking about other events that are one-time events, the severe and pervasive standard stemmed from the hostile workplace um, standard, which is one of the ways that you measure harassment. And that doesn't apply to a single event, but I think we should hew to the federal standard as much as possible and say that it still has to be a severe infringement. And in particular, not political speech.
I agree with that, by the way. I've actually advised several states to add a severe pervasive requirement. I think if you add the severe pervasive requirement, a lot of my concerns do go away. That way, the one-off comment to the bar function won't be enough, right? So actually, Professor Weiner are in complete agreement on that point. The severe pervasive standard is good. It's not clear to me that it would control, but if it was added to the black letter, or at least a comment, I think that would be a huge step forward. Good. Mr. Rovi, you want to jump in with some questions? I think you're on mute now.
I have a question, and I'd also like to invite anybody to who has a question to enter it, and I would be happy to read it out for you. Otherwise, I'll just sit here and ask my questions, but I'm more than happy to hear from all of you. First of all, I was curious about, Josh, you seem to single out sexual harassment, and you seem to view that as a problem that needs to be addressed more so than the other forms of harassment. And I'm curious about that because I find the language in the comment addressing sexual harassment pretty alarming. It says that I think it defines sexual harassment as including unwelcome sexual advances. It doesn't say pervasive. It doesn't say persistent. It doesn't say creating a hostile work environment. It doesn't limit that at all. And so I actually find that to be one of the larger flaws in the rule, that comment that defines sexual harassment so broadly. So I was wondering if you would address that. And my second point that is addressed to both of you is, what's the bar's interest in, I've been struggling with this, especially with the question about whether Trump's lawyers should be, this is a totally different question, but whether they should be disciplined for statements that they made outside of the court. And so what is the state's interest in regulating lawyers who are not inside the courtroom and are not representing clients? And how can we, I agree with Professor Weiner that we do regulate it, but there should be a break to that, I would think. And so I'm curious about what you both think.
Excellent. I'll try to answer both questions as carefully as I can. And I welcome Professor Weiner's comments as well. With respect to sexual harassment, you still have Title VII, and you still have the New York anti-discrimination laws. Those are always in effect. What happens if a person, say, is harassing a court reporter who's not their employee? Or perhaps, a person from law firm A is propositioning a person from law firm B, right? They're not in an employment relationship, so you wouldn't be able to use Title VII. I don't think, maybe correct me if I'm wrong, I don't think New York law would allow you a non-employee to sue. So this is basically sort of a layer on top of that, where if there's some sort of legal connection between person A and person B, even if there's no employment connection, you have it. You can bring some sort of claim, but still, I think it's much weaker than Title VII. I'm with you. Your second question, though, is foundational, right? What is the bar's role, right? Why does the bar have disciplinary power? I don't know about New York, but in most states, the state Supreme Court, the State Court of Appeals, gives this entity, the bar, power. And they say, we are giving you this monopoly on the license of practice of law. No, you can't have, the Josh Blackman bar license. I can't do that. That's not like a thing. So you get a monopoly on the practice of law, and you're responsible for disciplining those who violate the rules which are promulgated, right? So that's an awesome power to give this entity the ability to regulate this profession. And lawyers, for those law students listening, it's a self-regulated profession. It's been regulated by lawyers for forever, right? We largely govern ourselves. The bar prosecutors or the people, disciplinary managers, are lawyers, just like you and me, right? Anyone can sign up for this position and go to it. It's not like some sort of secret club. The proceedings are usually public, unless there's some reasons why maybe they're not public, and they're established rules. But where does the bar's jurisdiction begin and where does it end? And I view this question, Professor Rossi, I've given this thought as like a spectrum, and it's a hard question, right? If you're in a court, okay, you're in this sort of core, right? If you're submitting briefs to a court, you're in the sort of core. If you're in sort of legal proceeding related to court, maybe imagine a deposition, I think you're in that core. If you're engaging in transactional work and you have some sort of perhaps a due diligence meeting or something like that, you're there. If you're engaging in discovery, you're still in that core, right? But as you drift further and further, there's like a periphery. Oh God, don't hate me, a penumbra, if you will, right? There's this sort of this outer bounds of which it begins to be less clear that the bar has an interest. The bar does regulate CLE events, right? In order to get CLE, you have to submit an application to the state and they have to sign off. And I know there are some states that have denied CLE because they thought the topic was in violation of not 8.4, but their own state regime. So let's say wants to do an event on same-sex marriage and have a debate saying that Bergefell is wrong. And the state decides to say, we will not give the CLE credit because we think that would violate our SOGI regime, that this may be deemed harassing. Now, I think that would be a bad decision, but I think the state does have the power to withhold CLE credits. Would that violate the First Amendment? Maybe. Now I'll go one step further. The state gives credit as they authorize this CLE event on same-sex marriage or Title IX in bathrooms and transgender bathrooms, whatever, pick whatever topic you want to pick. But they authorize this event, and then someone makes a comment at this event, and then an attorney or even a lawsuit sitting there says, oh my God, I find this speech harassing. Maybe a dinner table conversation about Title IX in bathrooms. And then that person files a complaint with the bar. Now, it's true that maybe the bar complaint's dismissed after some time. You know, bar complaints, they're overworked. They don't always have time to do everything. In fact, there are a lot of very serious legal claims that aren't being addressed. People are spending client funds. You know, there's a lot of serious misconduct that's not getting addressed, which is maybe a topic for another debate. But when you get to that juncture where someone files a complaint, you have to hire a lawyer. Maybe if you're a first-year associate, your firm fires you, right? It's like, screw it, we don't have to waste our time with this guy. Maybe there's a campaign to shame you, and then your clients drop you, right? There's a bar complaint hanging over your head. That's a cost. That's sort of Damocles. So I would be very cautious of expanding the periphery, the penumbra, if you will, the bar, to merely conduct that's related to the practice of law. I would say maybe conduct in the practice of law or the practice of law itself, but it's one layer removed. That's my general sense, but it's a question I've grappled with. I don't have a good answer.
So I think the answer for me is at least partly found in the preamble to the rules of professional conduct, which points out that the legal profession, unlike other professions, is self-governing. And that's important because it preserves a level of independence that is important for the lawyer's role in the larger society. And to the extent that lawyers meet the obligations of their professional calling, and to the extent it is clear that the self-regulation is working, we can maintain it. We won't have legislatures or others trying to intervene and take over the regulation of the legal profession. That autonomy, as a practical matter, I think carries certain responsibilities. Ensure that we act that the regulations are in the public interest and not parochial interests. That lawyers observe the rules of professional conduct. But I think beyond that, lawyers do not want to be an example for the rest of society of the people who misbehave. It's a way to lose our privilege. And look at it this way, you know, an employment discrimination claim could be filed as a bar complaint or as a lawsuit in state court or both. But to the extent that the bar can deal with it, you minimize the interference with the independence of the profession. You minimize the prospect of the legislature getting involved. The sine qua non of self-regulation is public confidence. and judicial confidence. And that goes hand in hand with the effectiveness of the system. The sine qua non of the confidence is representativeness and legal compliance, and that's why I think we need a rule against discrimination, and that's why it needs to apply in anything related to the practice of law. There are lots of elements of life, at least I hope that there's elements of people's life that don't relate to the practice of law. And those are not fair game for the bar, except the rules do cover dishonesty and moral turpitude and all of those sorts of things. But by and large, it really is not that large a sway that the bar is asserting when it asserts jurisdiction over conduct related to the practice of law.
Okay, thank you. Josh, do you want to add anything there, or?
No, happy to move to other questions. I think
Yeah.
we've it's a really tough question. I think we've given those students here, I think, good positions on both sides. I'm happy to.
Right. Yeah. I mean, I would add, I often think of lawyers. I don't think that they have exactly the same First Amendment rights as everybody else, but I think in some contexts they have less, and in some contexts they may have more. And that's what makes this question so difficult, because on one level they're officers of the court, as that they could be regulated more, almost like a government employee, but they are also classic political speakers, and in that way should be regulated less, and that just makes it very, very complicated. I wanted to ask about the question of whether, which I think both of you agreed that there could be an 8.4G that would satisfy. I mean, I know that would satisfy you, Professor Weiner, but that would satisfy you. And I wonder if it would have to be whether part of the problem is the singling out of particular kinds of harassment that bothers you. So I wonder whether if we took out the classes, race, sex, religion, you named all of them, socioeconomic status, and just put a general anti-harassment and then redefined harassment as persistent and pervasive, whether that would satisfy you. And I also wanted to note that in the comments, the rule also says it's okay to discriminate, by the way, if you are discriminating in such a way as to advance diversity and help underrepresented minorities. So I want to know whether you think of that as a political statement there, or not. It seems to go directly against a kind of race neutral idea that obviously doesn't apply directly in this context, but at least one could theoretically think that it would.
Yeah, let me take your second question first. I'll answer your first question second. The rule specifically imposes a viewpoint discrimination, right? It's an express viewpoint discrimination. So comment 4 said, lawyers may engage in conduct undertaken to promote diversity and inclusion without violating this rule. Again, you can promote diversity. So if I have a policy or some sort of speech where I say we need to have affirmative action, we need to use race-based preferences, we need to use quotas that give certain underrepresented groups preferential hiring treatment, 30% of our corporate council must be Black, right? There's some entities that are doing that exactly now. That speech would not be in any way barred by 8.4G because it promotes diversity. This is a straight up viewpoint discrimination. If I take the opposite perspective, I say that these race-based programs are bad, that they're unconstitutional even if you're a government entity, and we shouldn't be using race in this fashion, right? That speech would not be insulated, would not be immunized by comment 4. And I think that gives away the ball game, right? The drafters of this rule recognize that there would be some right-wing rabble rousers who would who would file bar complaints against diversity committees saying, aha, you said Black Lives Matter. No, all lives matter, right? You can imagine that exact sort of complaints. They put in a little a carve out for their own activity. That's got to go. I mean, you need to not have that provision. If you want to protect speech about one side of diversity, you have to protect speech on the other side of diversity. This is not like this is not some sort of issue you can only pick one side of the debate. I think the first part of how you could draft this better, I think there are 10 or 11 grounds of protection Socioeconomic status is tricky, right? What if I said I want to hire a employee who is from an underrepresented background who grew up poor, right? I want to hire poor lawyers who know my community. I think that would violate the rule, right? Or you say I cater to wealthy country club types, some people who are wealthy. I want attorneys who grew up in a wealthy home. They understand these clientele. I don't think that's necessarily bad. I mean, it might not be favorable. I don't think Title VII bars that. I'm not sure at New York discrimination law if it bars socioeconomic. Maybe tell me, Professor Opie is nodding. So even the 11 they've enumerated, if you just knock out all those, I think that was your question, just say you cannot harass and use severe and pervasive. It's less problematic, I think, but still the concept of demeaning speech is not self-evident. And this phrase about demeaning speech could be used to slide very quickly into speech that people just find offensive. So the severe and pervasive is not a good thing, but it helps the rule survive any challenge because it eliminates sort of one-off comment, but it's severe or pervasive, or not and or. So a single really bad comment could, in theory, trigger liability. So, but it makes it better in my view.
So I think that severe or pervasive is an improvement. But I think pervasive has a narrower application to the kinds of conduct that the rule covers, because we're not talking about necessarily extended contact between individuals, and therefore pervasiveness is something that you would rarely achieve. But it seems to me that a particularly severe single comment, particularly an act of sexual harassment, I think one of them, if it's severe, sexual assault, aggressiveness in one way or another, I think that could well be that could well be covered by the rule and should be covered by the rule. Now, with regard to the question of discrimination, whether it's discrimination to promote diversity, I think the rule is really focused on invidious discrimination. But the important thing here is that discrimination is by and large conduct. And you just maybe there's some vocalization if you say you're fired. Yes, there's words in there, but it's really the conduct in firing people. And by and large, that's how you discriminate, not in terms of what you say, although there are exceptions to that. I think what would be viewpoint discrimination or would be if you said you cannot advocate discrimination on one basis or another, but you can advocate discrimination for purposes of diversity. Again, I think there's a distinction between discriminating and advocating discrimination, which is very important for First Amendment purposes.
David, I know you had a question. Why don't you go ahead?
All right. So my question is, in kind of today's society, we almost have a ever evolving meaning of words. And when it comes to harassment or discrimination in any of the states that have adopted some version of 8.4G, has there been an effort to really define what those two words mean?
I think the one state that adopted it was Vermont. Vermont sort of took the ABA's comment verbatim. And I'll be frank, the comment the ABA gave didn't do much to say what harassment was. It's defined as demeaning. And so what's demeaning? I don't know what demeaning is, right? When you actually try and define with precision what's prohibited, you realize you really can't, which is why they use sort of umbrella terms like harassment. Again, I would not want to be in front of the Supreme Court defending 8.4G. I think the current court at least would read it the same way the judge in Philadelphia read it. So again, if you want to prohibit a specific category for speech, you have to define it with precision. And when you start defining with precision, you have viewpoint discrimination problems, right? Which is your trap, right? If you leave it too vague, you have vagueness issues. If you go too precise, you have viewpoint issues. So that's, I think under the current law, it's like a minefield to try and do this, which is why I think it's best to keep this in the realm of where lawyers have just have regulated the past.
I agree that defining harassment is really difficult. And the situation for me that's difficult is take the New York Times, which I guess he resigned or was fired, the
Yeah.
reporter who used the N-word in the context of talking about the use of the word in a story about the language of racism and all that. And, to me, a single instance of that, I don't see that as harassment, but I think other people might disagree. I think that for purposes of, it's one thing what the New York Times can do, and another thing what the state can do. And when we're talking about the application of state power, you really have to take, I think, a very narrow definition.
Any other questions?
All right. Are there any other questions from students? Anybody else?
I think Professor Strauss is there. I know she's never one to not have a question.
Yeah, I don't know. She may not have gotten her tech issues
Uh-oh,
resolved.
uh-oh.
So
The only thing that can censor Nadine Strauss from
she
the
did.
Zoom.
she's there. there. Yeah. I mean, I could certainly ask a few more questions if other people don't have specific questions to ask.
I mean, I do know some students have
Yeah.
class at 2. I know that you do,
Yeah, as
Professor,
do
as
I,
well.
actually.
So, if no one else has any questions, I think we're okay, unless you have something
Okay.
you would like to ask. Yeah.
No, I would just like to say thank you so much. I've
Thank you.
really learned from both of you and appreciated the conversation. So, and thank you, David, and the Federalist Society for organizing this. It's been a pleasure to listen to you, and I hope our paths cross again soon.
Thank you so much, Professor Weiner, Professor Rofe. Appreciate it. And David, thank you so much.
Yes. No, thank you all
Thank
very
you.
much. We really appreciate it.
And we might not have given you as much adversity as you wanted, but
No, it was great.
a
Very
pleasure.
good.
Okay, everyone, take care. My power stayed on. Happy. Bye-bye.
Yeah.
Have a good one. Stay safe, everyone.